the defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
many of those do not interrupt me.
Picture this. A defendant on 2 separate criminal cases tells Judge Simpson he's suing him and expects it to work in his favor. This is Daniel McLoo facing fleeing and eluding, a felony, third offense, OWI, and escape from custody. Today we're breaking down how his plan to pressure the court backfires spectacularly. The case is called and Daniel goes on the offensive right away, arguing the unlawfully imprisoned charge can't apply since he was held in a hospital, not a jail, and challenging the license suspension charge on technical grounds. Judge Simpson isn't moved, denying the oral motion to dismiss and explaining that sufficiency arguments belong at a preliminary exam. Daniel then asks for that exact exam while also invoking his right to a speedy trial. A bit of a contradiction. The prosecutor confirms video discoveries is already on its way to him. Judge Simpson lets him talk, but never lets the jargon derail the process.
Mr. McLoo, starting in case ending in 0979. Mr. McLoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days, operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days, $500 fine plus court costs, and your vehicle would be subject to immobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitative programs court deems necessary. Court could order you to pay the cost of the prosecution, the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. McLoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance, given that I am incarcerated and I have no way to.
You wish to be represented by an attorney, sir?
Judge Simpson asks point blank whether Daniel wants a lawyer. Daniel dodges a few times, but the judge refuses to keep going in circles and forces a straight answer. Daniel finally admits he wants legal help, and both cases are handed over to the public defender's office. It's a telling moment. After all that confident self-representation, he backs down the second reel. Accountability is on the table. Then things shift again. Daniel argues that a 390-day gap between the warrant and his arraignment violates due process, citing case law and demanding the prosecutor justify the delay under a specific legal test. He follows it up with a request for a personal recognizance bond, leaning on constitutional language. It sounds rehearsed, but it conveniently skips over the fact that one of his charges is escaping custody.
He's asked for a preliminary examination, and I realize where this may be my understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That bond has been denied, so.
That's what
I would do
Mr. Curtis said.
in any event. But also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in this case, bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Custody of.
I was dropped off at the hospital and they later tacked on
And
charges
you know
just
what?
like the
The
fleeing and
evidence
eluding
will
charge.
not meet that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
If this case already has you hooked, you're in the right place. Like and subscribe to Court with Mia. I cover the most epic, jaw-dropping court cases you won't believe are real.
Thank you very much.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with the court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen. And then he's attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant. And so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there. They will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shake this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
Been aware of such note or such filings we received by my office maybe yesterday. At this point, we continue to proceed with this case until I do otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
Wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Somebody be able to continue.
By the end of this hearing, Daniel's lawsuit, his venue request, and his statutory arguments all landed the same place: denied. Judge Simpson stayed composed and never let the threat of a lawsuit steer a single ruling. He handled a clear pressure tactic exactly the way a judge should. Do you think the bond should have been reconsidered? Let us know in the comments. That's a wrap on another epic case, and honestly, I have so many more where that came from. Drop a comment and tell me what you thought, and make sure you're subscribed to Court with Mia so you never miss the next one. See you there.